will regulated militia be necessary to the security of a free state? The right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad you're with us on the program today. We're going to be taking a sort of another 50,000-foot look at the year ahead. Last program, the first one of 2023, we spoke with Mark Walters, host of Armed American Radio. Joining us on today's program, Larry Keane, Senior Vice President and General Counsel of the National Shooting Sports Foundation, otherwise known as the Gun Industry Lobby, right, according to the anti-gun folks out there. We've got a lengthy conversation with Larry touching on again, some of the biggest threats to the firearms industry, as well as some hopefully opportunities for the industry as well this year. And of course, those threats to the firearms industry ultimately end up being a threat to our right to keep and bear arms. We've already seen the Biden administration go after home-built firearms, right? So they don't want you to be able to make your gun at home. They really don't want you to be able to buy your firearm in a store either. If they can't repeal the Second Amendment, they can at least turn it into, well, I won't say at least, they can try to turn it into a non-entity by either bankrupting the firearms industry or imposing so many numerous regulations that you have to navigate a legal minefield in order to exercise a fundamental constitutional right. So with that in mind, take a look and a listen to our conversation with Larry Keane of the NSSF. Well, Larry, happy 2023 to you. Thanks so much for coming on Cam and Company.
Thanks, Cam. Always a pleasure to spend time with you. Hope you had a nice holidays.
I did. And, now we're right back to it. Listen, 2023 is starting off in a very big way. I mean, you've got, potential gun bans on the move in states like Illinois, lots of lawsuits going on, both, in defense of our Second Amendment rights and, unfortunately, lawsuits trying to deprive us of our right to keep and bear arms. I want to ask you just a general question. First off, what are NSSF's biggest priorities for the new year?
It's a great question, and I've spent a lot of time thinking about that in the last few days as we begin the 118th Congress, as soon as the speakers determine, which is a whole other conversation. So what are our priorities, and what is feasible, what is infeasible given the political realities? It's not going to be possible to pass pro-gun legislation in Congress or to pass anti-gun legislation in Congress. So the only things that can pass in Congress that affects our world really is conservation policy legislation that tends to be bipartisan. So that's possible, and so there's some good things there. Anything on the policy side really has to focus on appropriations language, report language. There will be a lot of oversight hearings in the House. Had conversations yesterday with Chairman Comer, for example, on the appropriations side. I had a conversation yesterday with Congressman Zinke, who's returned to Congress in the 118th. So that'll be the focus, a lot of oversight hearings on ATF, DOJ, the FBI, that sort of thing, and as well as Interior, Fish and Wildlife. We are very concerned with the administration's anti-traditional ammunition view. They want to ban the use of traditional ammunition, and they're taking steps to implement those policies. So we got to try to stop that and protect traditional ammunition because those policies are not based on science. It's based on caving to pressure from anti-hunting groups and radical environmental groups like the Center for Biodiversity. So, trying to figure that out now and try to prioritize. Certain pieces of legislation will seek to have reintroduced, like the Fair Access to Banking and the FIND Act, for sure, will seek to have reintroduced. So, we got to wait for chairman to come in. We got to wait for staff to be hired and assigned, and before we can really start moving. But we expect to see some legislation introduced in this Congress again, like the Fair Access to Banking and the FIND Act and others, right away. And then we're working towards other legislation that might get introduced. Even if it doesn't move and become law, it sends a message, and it often takes many, many years to get legislation actually passed. So you have to keep at it, reintroduce it, keep building the case for the legislation. So.
Yeah, I'm thinking of Representative Richard Hudson's National Right to Carry Reciprocity Act. That was the first bill that came to mind. That you just keep reintroducing it and keep hoping you get some progress each and every year. Now, you talked about the oversight role that that the House is going to have, and I think it's really important because, as you say, with the opportunity for both pro and anti-gun legislation to move through Congress, largely tied up, I think, because of the partisan and split divide there. I'm a little concerned, Larry, about the administrative actions that we might be seeing from the White House. So let me ask you, what do you anticipate coming down the road from ATF this year? We still have the stabilizing brace issue out there, right?
Yeah, the brace rule will come out sometime this month, and I expect it'll come out right before SHOT Show, or right at the time of SHOT Show. They filed some papers in a case the other day indicating they anticipated the final rule would come out in January. And there's a long history, frankly, of ATF making major announcements at the SHOT Show and then being there to discuss it with members of industry. So that'll happen. We saw the letter to industry that just came out the other day purporting to clarify the prior final rule. And as is often the case when ATF puts out these clarifying letters, they just make things more confused. That's the sort of ghost gun issue. And that is clearly just in response to pressure from anti-gun groups that aren't happy that the rule it doesn't go far enough in their opinion. Of course, ATF is confined by the language of the Gun Control Act. We think they have stretched that language beyond recognition, and we think that final rule is really built on a house of cards. It's it's a foundation built in sand because they're misreading the statute to advance this policy.
Well, and it is interesting that the ATF came out and originally said, because there was one of the lawsuits that had been filed over the quote unquote ghost gun rules. There was this fascinating exchange where the plaintiff, I think it wasn't for Polymer 80, but it was for a Texas company, had argued, listen, this law is going to apply to us, or this rule is going to apply to us. We don't make the kits, but we make the individual 80% lowers. And the DOJ attorney said, no, you guys are fine. It only covers kits. And the judge said, well, I mean, does that kind of moot your case? And the attorney said, well, no, because this rule is written so vaguely. And then here we are just a couple months later, ATF, what the DOJ said in court is no longer true. Now DOJ says, no, it doesn't just apply to the kits. Now it does apply to these individual 80% receivers. And again, Larry, as you say, it appears that 180-degree reversal was the result solely of lobbying on the part of the gun control groups who wanted a more expansive reading of the ATF's rule.
So when the rule first came out, the gun control groups were, taking a victory lap.
Mm-hmm.
And then they bothered to read the rule, and it doesn't do what they thought it did. The lawyer for DOJ in Texas was actually correct. The rule doesn't ban 80% receivers. They can't ban something that is not yet a frame or receiver because the statute defines firearms as A, weapons or readily convertible to a weapon, B, frame or receiver. It doesn't say B, frame or receiver or readily convertible to a frame or receiver. And that's the false basis of the entire rule. It's built on, house of cards. That is not what the statute says. We pointed that out in our comment letter. So after gun control groups bothered to read the rule, they were like, oh, this doesn't do what we want it to do. They went back and sued ATF because the rule didn't do what they wanted. Now, that lawsuit, as far as I know, is still pending. They clearly would have no standing to bring that challenge. You don't get to sue because you don't like the rule or you don't think the rule goes far enough. But what did ATF do? Now they've clarified. And depending on how you read that, and I read it and scratching my head to try to figure out what it actually says, to make the argument that they are now saying 80% receivers. So, but this has been a perennial question since they've adopted this false reading of the statute. when is a hunk of metal, a frame or receiver, and when is it a hunk of metal? If it's a hunk of metal, it's not regulated because the statute says frame or receiver. And so until it's a frame or receiver, stretching and stretching and stretching, and then you got, these rulings, and that's where the term, if it's completed partially, but not all the way, so it's 80% done, it's not a frame receiver, it's not regulated. Now they're trying to say, and we went, for years and years. And the reason it matters, like the major manufacturers who don't sell 80% receivers, is when it becomes a frame or receiver is when record keeping and marking requirements kick in. So like the big guys, they need to know, when is it a frame or receiver? And it's a little bit like the old sort of Supreme Court line about pornography. I can't define it, but I know it when I see it. And the answer is, we can't really define it. Send it in and we'll tell you. Of course, there's no legal requirement that you send it in. You're supposed to be able to read a statute and understand it for yourself.
Right.
Due process, right? Like, and if you can, it's void. It's void. What we lawyers call void for vagueness. So, but I think it is very challenging for ATF to say, well, this is the criteria, and they articulated the best I ever saw in the lawsuits by the gun control groups against ATF under the Trump administration. ATF, in one of their filings, laid out exactly how they look at an object and decide. And that was the clearest articulation I'd ever seen by ATF. I remember sharing that with folks in the industry and say, hey, pay attention. This is the clearest, articulation of how they evaluate it. And so there's a little bit of that, like indexing. If you put like a little circle and say drill here, right? Like, or indentation. So this is where you drill. They were saying, well, that's close enough to be considered a frame or receiver because, and then they made the argument, right? They did the raid of Polymer 80, the buy, build, and shoot kits, which nothing ever came of that because everything in the kit is not regulated. So how does the, amalgamation of all of those unregulated parts make it all of a sudden regulated, right? And they never prosecuted Polymer 80 after that raid of their warehouse in Nevada, I think it was. So we're back to that. And so the rule was understood as, so long as you don't sell the kit, right, all together, that's the problem. So you can't do that as articulated by the rule and as it was understood and has ATF explained it to folks in the industry. And now they seem to have moved that line in response to a lawsuit by the gun control groups. And I bet you now, my guess is that lawsuit now magically goes away.
I'm guessing you're right, but listen, given what we've seen with the 80% frames and receivers, given what we've seen with the gun control groups lobbying the CDC to remove defensive gun use data from their studies, I think there's a genuine concern that the anti-gunners have a lot of sway in this administration. And one of the things that they've been pushing, Larry, is the idea of if they can't get a gun ban through Congress, well, why can't they do one through regulation, right? Why can't we declare that a certain number of semi-automatic firearms are readily converted to machine guns and therefore should be classified as machine guns under the NFA? We've seen, the Brady campaign has made this argument in court filings. The Trace had a big story a couple of months ago laying out how the ATF could do this without a vote in Congress. It sounds kind of crazy. I call it the nuclear option for the Biden administration if they want to do a gun ban. But how concerned are you and how concerned is the industry that the administration may actually take that step this year?
Well, certainly this argument we see in court, chiefly coming, but not exclusively from the Brady Center, that somehow a semi-automatic rifle, an AR-15, a modern sporting rifle, is a machine gun. And so therefore, when it was sold as a semi-automatic rifle legally, right, for decades, and classified by ATF as being a semi-automatic and not an automatic firearm, and then therefore an NFA item, we are concerned about it. We're seeing it in court, and it hasn't really been rejected by the courts as absurd on its face. We've talked to ATF about this, and what they have told us is the NFA, the statute says readily restored, not readily converted, right? So it has to have been a machine gun in the first place to be restored to operate as an automatic firearm. So, but it is very concerning. This is a lot of the same conversations or concerns that we heard during the Obama administration when they couldn't pass gun legislation.
Mm-hmm.
That they're going to use administrative power, and the administration does have a lot of room to maneuver in that space, and there are lots of things I suppose that they could do. I don't want to say anything here about because I don't know what that is, right? So,
no, we don't want to walk down that road.
But do I think they can say or will say AR-15s are actually machine guns? I don't think so, because then they have to admit that would be to admit that since 1963 they have allowed machine guns to be sold. I don't think ATF is going to go there. But I mean, we see them stretching the envelope with these rulings and these. We're going to see what happens with the pistol race that'll come out. I mean, they said these things weren't, but I think it's going to be hard to challenge that ruling, because the ruling doesn't say you can't have these. It just says this is the test. Of course, when you try to apply the test, basically everything fails. And I love the part of the proposed rule where it says, here's the test. If you pass the test, we can still say it's banned. So how is the average person supposed to know? Well, I've got this thing, I bought it legally.
Yeah.
I don't know. What do you do? And they don't. I mean,
which I think is a feature, not a bug, by the way, of the rule, to make it as hard to understand and as hard to comply with as possible. I think that's one of the goals of the anti-gun side. Yeah. All right. Listen, Larry, I know we've only got a couple of minutes left. I could talk to you all hour because there's so much stuff going on here. But, you talk about whether or not the stabilizing brace rule can withstand a court challenge. We know that the courts obviously are going to be hopping. They have been since the Bruin decision. I think that's going to continue to be the case in 2023. What are just I'll just make this a quick one, and we'll have you back on and delve deeper into some of the illegal cases. But what are some of the ones that some of the big lawsuits that NSSF is interested in? Obviously, you all are involved in a couple of lawsuits, right? Taking on some of these provisions that are in essence designed to encourage junk lawsuits against the industry. But what else is it that the industry is looking at here this year?
Well, so certainly the rise of public nuisance claims again. So the New York law that we challenged, that's now in the Second Circuit, we filed in New Jersey and Delaware with statutes with essentially similar laws allowing public nuisance claims. They are an attempt to sidestep the Protection of Lawful Commerce and Arms Act and say, well, now there's a statutory claim, and so we can bring the action. And we've now also seen lawsuits filed in New York by the city of Buffalo and the city of Rochester against essentially the entire industry, based on the New York public nuisance statute. So those were just filed right before Christmas. No one has been served yet, but those are very important. We are involved in the Oregon litigation against Measure 114, and we anticipate being involved in filing a lawsuit in Illinois if they pass an assault weapons ban, in Washington State if they pass an assault weapons ban. And there is a magazine capacity restriction law in Rhode Island where a federal court denied a motion for a preliminary injunction. And we're working with the plaintiffs in that case. And Clement and Murphy, Paul Clement, the former Solicitor General, will be handling that appeal on behalf of those plaintiffs. Because the decision is just so bad wrong and really bad law. So there's the Mexican lawsuit against the dealers in Arizona we're concerned about, and the Mexican lawsuit against the industry out of Boston, which is on appeal, we're concerned about. And then there's the advertising to minor law in California. We're watching that. We may or may not bring an action there. There's the fortunately, the fee shifting provision was struck down, but we've been asked about the public, the sort of Texas model legislation in California where anybody can sue. I don't think that we will be filing a facial challenge to that law because it requires an underlying violation of California law in order to bring an action. If there's an action, it depends on, we may look at that. But it's also, I think, in a clear attempt to sidestep the PLCAA. And I think there are, like the Texas abortion law, frankly, there are serious standing issues about whether somebody completely disconnected and not affected in any way, no injury, in California can file because somebody was somehow was in illegal possession or misused a firearm. Somebody in Southern California and somebody from, San Francisco with absolutely no connection. And another question would be, let's say you have one event in California. Can every single citizen in California file a lawsuit against an industry member for that one event? According to the statute, yes. That's obviously absurd. So there are problems with that statute. I think we have to wait to see if it ever gets applied. I suspect it will, and then we'll deal with it at that time. I don't think it's susceptible to a facial challenge because in a facial challenge you have to say there was no possibility, no possible set of facts where the statute cannot be applied. And so if for example, you had Acme guns, break the law and sell banned firearms in California, they could be sued, right? And in that case, they wouldn't have any protection under the Protection of Lawful Commerce and Arms Act because of the predicate exception. So we have to see how that plays out. We're definitely interested in the advertising to minor case, and there are two of those. And the other case that's important out there, and kudos to Chuck Michelle for pursuing this, is a challenge to the handgun roster post-Bruin.
Yeah.
I mean, and you see all the cases in New York now, in New Jersey, with these, state laws being passed that really are just, poking, sticking their thumb in the eye of the Supreme Court and really just defying the Supreme Court. So I do hope we will see the Supreme Court accept, an assault weapons ban case, a magazine capacity restriction case, many of the cases that were, on its way to the Supreme Court where cert was granted and then it was sent back. There's a challenge in the Fourth Circuit to the Colby decision in Maryland, the Maryland assault weapons ban. That has been argued before the Fourth Circuit. I listened to the argument, and I thought the argument went very well for our side. Always reading tea leaves, but that could be, on its way back to the Supreme Court or to the Supreme Court. And then we'll see what happens in like the cases out in California, Duncan and all of those cases. So I do think the Supreme Court in the next, 3 to 5 years will take, I hope, there will certainly be asked to take some more Second Amendment cases.
Yeah. Oh, yeah, absolutely. And I think, as you say, the Fourth Circuit case dealing with Maryland's ban on so-called assault weapons, it'll be interesting to see what happens if the Fourth Circuit decides that the ban is actually unconstitutional, whether Maryland will appeal that to the Supreme Court. But I guess we'll have to wait and see.
As we see all the time, all the time in the Ninth Circuit, even if you win, it goes on and you lose. Right.
Right. That's that. Okay. Very good point.
Yeah.
Larry, listen.
My expectation is that we will win. That's Bianchi's the name of the case. It just came back to me 2-1. But I think you could see it go on back. But you're exactly right. The state has to do that political calculus. If we take it to the Supreme Court, are we likely to lose? And then it's bad law. Then they create bad law. So from their perspective, but if the court rules in favor of the plaintiffs in that case, and there's no en banc, or they go en banc and the court says, well, Bruin says what it says, and so the state loses, the plaintiffs win, But if it goes the other way and they say, no, panel was wrong, that's not what Bruin says, then the path to the Supreme Court is decided by the plaintiffs, not state of Maryland. So
Yeah.
that's part of the calculation. Well, what do I
Right.
Bob? So.
Yep. Well, there are a lot of cases to keep our eyes on, and I know we'll be talking about a lot of them with you over the course of this year, as well as the latest machinations there on Capitol Hill and from the ATF and some of the other alphabet agencies. But Larry, as always, really appreciate you spending some time with us today, and I look forward to doing this again very, very soon. Thanks for all of the information. I appreciate Larry joining us on the program, and we'll be talking with him again very soon. But now let's turn our attention to today's armed citizen story, our good deed of the day, as well as our recidivist report. We'll start there with a case out of Pennsylvania, where the police chief in Breckenridge, Pennsylvania, was shot and killed. A officer wounded the suspect in that case, the individual accused of killing the police chief and shooting at police officers. No surprise. Not someone who was unknown to local police in the Pittsburgh area. Aaron Swan Jr., who was shot and killed when he got into a shootout with police on Monday night in the Homewood neighborhood of Pittsburgh. His criminal history dates back a decade. Starts in 2013 when he pleaded guilty to theft and disorderly conduct. He got probation for that sentence, which is not outside of the realm of the normal, right? And again, theft, disorderly conduct, these are nonviolent offenses. It's a first offense. So that's actually understandable. You'd get a slap on the wrist. You'd get probation, and you'd be told, don't do it again. The very next year, however, Swan was charged with homicide when a man was found dead in the parking lot of a Baptist church. Now, prosecutors ended up withdrawing that charge, only though after Swan agreed to cooperate and testify against another man who ended up being convicted of the murder. Instead, Swan pleaded guilty to robbery/serious bodily injury and conspiracy. And that's when he did receive a sweetheart deal. In exchange for his testimony, Swan was sentenced to 3 to 6 years in prison. That's bad enough, but he only served a little more than a year behind bars when he was released. Now, again, I understand. If you want to go after, the person you believe is most responsible for a crime, you offer co-conspirators or ancillary figures a plea deal, cooperate with us, and in exchange for your testimony, we'll prosecute you or allow you to plead guilty to lesser charges so we can get this guy and put him away. However, when you do 33% of the low end of your plea deal sentence, that's I think, a bit egregious. In 2017, court records show that Swan received probation after pleading guilty to having an illegal firearm. As a convicted felon, I might add. Taunting a police animal, escape, reckless endangerment, criminal trespass, and resisting arrest. That is just mind-blowing to me. Probation for being a felon in possession of a firearm, a violent felon, by the way, in possession of a firearm. But he got probation. In 2019, Swan pleaded guilty to drug distribution and was then sent back to prison, right? So having the illegal gun, you're fine. Illegal drugs, now you're going back to jail. He was released on parole in June of 2021. In November of 2021, he was charged with theft, simple assault, terroristic threats. Police report says that Swan stole a pistol from a car in Pittsburgh. When the gun owner showed up, the two men fought. Police say Swan threatened to kill the gun owner and then ran to a nearby park. Police never caught up with him that day. It was several weeks later. Police tracked Swan to an apartment complex using Apple AirPods that Swan had allegedly stolen. Officers found him asleep in his car with a pistol, ordered him to get out. He tried to drive away, but his car got stuck. Police report says he jumped out of the car and then ran into the nearby woods and was never apprehended. His parole was revoked 4 months later, in April of 2022, after he failed to report to his parole officer. Yeah, and then again, just earlier this week, Breckenridge Police Chief Justin McIntyre and a police officer from Tarentum, Pennsylvania, shot, allegedly by Swan, when arguably Swan should have and easily could have been behind bars instead of out on the street. Today's armed citizen story from WAOW, Elderon, Wisconsin. where an elderly man had to deal with a 22-year-old trying to invade his home. That elderly man ended up shooting and killing the much younger intruder. According to local news reports, the 79-year-old man was followed home from a local establishment. He was basically picked out by the intended robber, trailed to his home, and then that 22-year-old literally tried to break in. Deputies from the Marathon County Sheriff's Office dispatched at about 2:30 in the morning to a residence in Elderon for a report of a man who had been assaulted and stabbed in the face as he got out of his car in his garage. The release from the Marathon County Sheriff's Office says that the elderly man was in possession of a firearm and fired one round that struck the 22-year-old suspect prior to the firearm being wrestled away from him. The suspect suffered a gunshot wound to the chest and died while fleeing the scene. 79-year-old man sustained non-life-threatening injuries and is recovering at a local hospital. Now, again, if this 79-year-old man had to square off against a 22-year-old in his garage, unarmed and defenseless, I'm guessing that we may still have had a homicide, but it would not have been a justifiable homicide. Instead, it would have been outright murder. Not only a home invasion, not only an armed robbery, but the death of an innocent victim as well. Because this 79-year-old man was able to protect himself against a much younger individual in the sanctity of his own garage. Again, pulled into his garage, thinking he's safe and sound at home, and that's when he was attacked. Again, thankfully, the 79-year-old man had the presence of mind to be able to protect himself, not only in his residence, but, coming to and from as well. I'm glad that he is going to recover from his injuries. I feel bad for the family of the 22-year-old who made such a stupid and fatal mistake. But I'm very, very gratified that the homeowner in question is alive, thanks to his ability to protect and defend himself. Finally today, our good deed of the day. On a New York City subway, one of the many gun-free zones in New York City, criminals seem to understand they are unlikely to run across any armed victims able and willing to fight back. And frankly, all too often, when you see somebody accosted on a subway car or a violent robbery that occurs, most of the other folks on that train don't want to get involved, right? And again, I kind of understand. Why would you want to put yourself in danger? Why would you want to put yourself at risk if, again, you can't protect yourself? Well, thankfully, there was one Good Samaritan in New York City who, despite the fact that he was unarmed, did do the right thing, did step up and help to stop a rape of an 18-year-old woman on a subway in New York City. According to Fox 5 in New York, happened Sunday just before 10 o'clock in the evening, Upper West Side of Manhattan. Police say the victim was followed by the suspect onto a southbound train in Harlem. Police say the suspect then exposed himself and attempted to pull the victim's pants down while the train was approaching the 72nd Street subway station. That is when a Good Samaritan intervened and helped the victim flee the train car and run to another to safety. The suspect remained on the train, then detrained at the 42nd Street subway station, where he fled. No police involvement whatsoever, apparently, within the subway system. Suspect is still at large. Fox 5 reports that the victim traveled by private means to a local hospital for treatment and evaluation. The Good Samaritan hasn't been identified either. But as Fox 5 reports, this comes after a violent Christmas last month in the subway system where there were at least 4 separate incidents, fairly, again, violent incidents on the subway system. A gun-free zone, according to New York City. Criminals don't seem to care. They view that as a target-rich environment. And that is going to do it for this edition of Bearing Arms Cam & Company. I want to thank you for being a part of the program as always, and looking forward to speaking with you again tomorrow for the last Cam & Company of the week. It's weird. I've been off, literally, I was off on Monday, and I've been off as a result all week long. But we will be back tomorrow, and I would encourage you to check out BearingArms.com throughout the day today, where we will be updating the website with all of the latest Second Amendment news and information that you need to know about. If you like what you see, I'd also encourage you to become a VIP or a VIP Gold subscriber. In addition to getting that warm, fuzzy feeling from supporting our independent pro-Second Amendment journalism, we're going to give you exclusive commentary, analysis, news stories you won't find anywhere else. because your support does matter, and it really does make a difference. So thank you again. Have a great rest of your Hump Day Wednesday. We'll see you back here tomorrow. Until then, be well, be safe, and be free.